Good afternoon, fellow faculty, students, alumni, staff, and friends. Welcome to the installation of William M. Traynor as the Paul Regis Dean Leadership Professor of Law. This is a special day, and we gather for several reasons. Today, we honor Dean William M. Traynor, and I would like to welcome and acknowledge Dean Traynor and his family, including his wife, Allison, his son, Liam, and his daughter, Catherine, who are here with us in the front row. And also the president of Georgetown University, John Jack DeGioia. I have the honor to introduce the introducer, the Honorable Robert Katzman. And later in the program, we'll hear from some of my other colleagues, Associate Dean Chris Henning, Associate Dean John McKyle, and of course, from Bill himself. But I'd like to take this opportunity first to introduce the Honorable Robert Katzman, who's the Chief Judge of the United States Second Circuit Court of Appeals. He assumed that position in September 2013. When he was appointed to the federal bench in 1999, he was the Walsh Professor of Government, Professor of Law, and Professor of Public Policy at Georgetown University. We were sorry to lose him, but the bench gained a great scholar and advocate. He was also a fellow of the Governmental Studies program at the Brookings Institution and president of the Governance Institute. He likes to keep busy. A lawyer and a political scientist by training, Judge Katzman received his A.B. from Columbia College, summa cum laude, an A.M. and a Ph.D. in government from Harvard, and a J.D. from Yale Law School, where he was article and book review editor of the Yale Law Journal. After clerking on the U.S. Court of Appeals for the First Circuit, he joined the Brookings Institution, where he was a research associate, senior fellow, visiting fellow, and acting program director. His books include the recently published Judging Statutes, Regulatory Bureaucracy, Institutional Disability, Courts and Congress, and he was the editor and project director of The Law Firm and the Public Good, co-editor of Managing Appeals in the Federal Court, contributing and editor of Daniel Patrick Moynihan, The Intellectual and Public Life, and editor and contributing editor of Judges and Legislators. In his early years on the bench, Judge Katzman witnessed the inadequate legal representation of non-citizens and the adverse impact on the fair and effective administration of justice. Greatly concerned, in 2007, he delivered the Marden Lecture at the New York City Bar Association, The Legal Profession and the Unmet Needs of the Immigrant Poor. And inspired by the enthusiastic response, he soon after organized an interdisciplinary study group on immigration and immigrant representation, from which emanated the New York Immigrant Family Unity Project, the first government-funded program of legal counsel for detained non-citizens. Chief Judge Katzman sparked also the creation in 2014 of the nonprofit Immigrant Justice Corps, the country's first fellowship program for recent law school and college graduates dedicated to meeting the need for high-quality legal assistance for immigrants. As Chief Judge, he also launched a wide-ranging civic education initiative of the federal courts of the Second Circuit, Justice for All Counts and the Community. Justice for All Courts and the Community, to increase the public understanding of federal judiciary and to bring courts closer to the communities they serve. During his tenure as Chief Judge, the Court of Appeals also undertook a 125th anniversary retrospective. He has many honors, including the Learned Hand Medal of the Federal Bar Council, the Edward Weinfeld Award of the New York County Lawyers Association, the Fuld Award of the New York State Bar Association, the Green Bag Award for Legal Writing, the Charles E. Merriam Award of the American Political Science Association, the Thurgood Marshall Award of the American Bar Association, membership as a Fellow of the American Academy of Arts and Sciences, and honorary degrees from New York Law School, John Jay College, and Pace University. He served on many judicial and government committees and on law school boards, including, by appointment of the Chief Justice, as chair of the U.S. Judicial Conference Committee on the Judicial Branch, a member of the Executive Committee of the U.S. Judicial Conference, and as chair of the Supreme Court Fellows Commission. So I'd like you to help me welcome Judge Katzman to the podium.
Thank you. Thank you, Jim Feinerman. It's wonderful to be back at Georgetown, this extraordinary institution. And what a privilege it is to be here, to be part of this day honoring Dean Traynor. someone we all agree is a great human being of many dimensions. My role is to help move things along as a prelude to hearing from our various speakers, who will touch upon Bill's singularly remarkable career as a visionary law school dean, as a scholar, teacher, and a public servant. Such is the depth of his excellence that Bill would be deserving of a chair on the basis only of his law school deanship. He would be deserving of a chair only on the basis of his scholarship. He would merit a chair only on the basis of his teaching. He would be deserving of the chair if only the basis were his public service and his service to the community. Indeed, it is unfathomable that one person could do so much and so brilliantly. William Traynor is that singular talent, rare and special beyond measure. In that assessment, I am in good company. Justices Ginsburg and Sotomayor recently remarked with admiration about Bill's extraordinary contribution to our world. What to make of this gifted human being, Bill Traynor, of so many parts? Dean Traynor is the epitome of the Augustinian ideal of the contemplative in action. If there is anything that unites Bill's life as a law school dean, scholar, and public servant, it is for him the centrality of law and justice, the importance of academic inquiry and debate, the value of educating the whole person, the commitment to the view that each person is important and should be nurtured and mentored to realize his or her potential, the need to promote diversity, the importance of making the law school run well so that all other goals can be served. He and his wife, Allison, have a deep capacity for friendship. They are friends for all seasons, and good times and not so good times. Their kindness, their generous spirits make the world a better place. My view, I think, is shared by all of us who know Bill, because Bill and Allison treat everyone as if he or she is special. So as we are honoring Bill with this chair in honor of a great dean, I thought I'd ask two other great deans for their candid assessment of Bill Traynor. And so I turned to two, Guido Calabresi, the former dean of the Yale Law School and now my colleague on the Second Circuit, and John Feerick, former dean of the Fordham Law School. With insight and elegance, Judge Calabresi put it this way, and I quote, "Bill Traynor is more nearly unique than rare. He has managed to be a long-standing and very successful dean, and yet he remains an unerring and truly innovative scholar. To be able to do decent scholarly work while dean is difficult. To be able to do it at Bill's level is extraordinary." And Dean Feerick wrote, "Dean Traynor served as a professor in Fordham Law School for 18 years, achieving the highest level of excellence as a teacher, scholar, and servant of others. 8 of those years were as the 9th dean of the school, during which he took the school through a glorious celebration of its 100th anniversary, developed the plans for a magnificent new law school building, including the associated fundraising, and empowered every part of the law school, making it a family and a community unique in its history. Might I add also," he said, "that he also, that is Bill, created the Law Center's Center for Feerick Justice, which he asked me to found so that law students would be introduced to the importance of social justice lawyering." That's the Feerick Center. Now a snapshot of what it is that will follow. From Chris Henning, the Associate Dean for Experiential Learning, we will hear about Bill's path-breaking academic leadership that is acknowledged nationwide at 2 law schools. As an academic leader at Georgetown, it is extraordinary what he has accomplished, I might observe from a distance. We all know that a primary function of a dean is to raise money, and it's hard to think of somebody who's done a better job of that than Bill. Last year alone, he raised over $40 million with his great team. Each of the last 4 years has been one of the 4 best fundraising years in Georgetown's law school history. The faculty is extraordinary, with 60 new full-time faculty members, including 39 tenured or tenure-track faculty. We'll hear more about this when Chris speaks. Then we'll hear from John Mikhail, the Associate Dean for Research, who will talk about Dean Trainor's highly influential scholarship and training. I scarcely can tell you how much I admire Bill's scholarship. He is a constitutional historian and a theorist who examines cutting-edge issues in the law through an historian's lens. And so his work on the original understanding of the Constitution has challenged conventional wisdom. His work on judicial review, showing how judicial review was prevalent before Madison, to an extent not previously as well recognized, is a huge contribution. I could go on and on. Drawing upon his work as Deputy Assistant Attorney General and as an Iran-Contra Associate Counsel and his personal understanding of the political process, he has written about a whole range of issues, from looking at models for selecting independent counsel, how to think about what to do about statutes pronounced unconstitutional, looking at intellectual property and the takings clause. Truly amazing. And apart from the scholarship, there is the teaching. I know from law clerks who've had Bill as a mentor, some of whom are on this faculty, that Bill really is somebody who inspires the students, and they achieve great things because he gives them the sense that anything is possible. And as to his public service, his contributions are many and distinguished. He was Deputy Assistant Attorney General in the Office of Legal Counsel, the Department of Justice, and we all know how critically important that office is. He was an Associate Independent Counsel in the Iran-Contra investigation. He's been on many public service boards. And as Chief Judge, I have turned to Bill for his counsel and participation often. He's addressed our Circuit Judicial Conference of Judges. When I was chair of the Judicial Branch Committee, I asked him to speak before a gathering of the House and Senate Judiciary Committees about his scholarship. Most of those who said yes, they would come, said, well, we'll just come for a few minutes, and then we have to go off to our reception to obviously raise money. They didn't say obviously raise money, but that was it. But what was striking was how many of them actually stayed. They stayed for the whole time. And I remember Chairman Nadler, who had an extraordinarily busy schedule, stayed for the whole talk. And that was because Bill is such a compelling and wonderful speaker. Well, I could go on for hours talking about Bill, but now it's time to give others their opportunities to speak about Dean William Trainor. First, Dean Henning, then Dean Mikhail, and then Dean Feinerman, who will confer the medal on Dean Trainor and invite him to deliver remarks. Dean Henning.
So, as some of you know, when Bill first asked me to serve as Associate Dean, I was quite reluctant. And in fact, I may have said no more than once before I finally gave in. But I have never forgotten the conversation that he and I had when I finally said yes. I was telling Bill that I was worried that being an Associate Dean would interfere with my work as an advocate and an activist around juvenile and criminal justice reform. And he stopped me and he said, "But Chris, being a dean gives you a platform and greater opportunity and greater impact on justice." And although I was still a bit reluctant, I agreed. And I have to tell you, over the last 2 years, I have had an opportunity to watch up close and personal, to see Bill exemplify and model true servant leadership. I can tell you that Bill does not serve for status and prestige. And as cliche as it may sound, Bill truly serves to make this world a better place. Like any good servant leader, Bill has used his resources, his power, and his influence to actualize what we mean at Georgetown about social justice. He has used his power and influence to ensure access and opportunity for a wide range of students interested in the legal profession. He has worked to guarantee diversity and inclusion in the law school and to broaden our footprint on the local, national, and international affairs. Since he arrived in 2010, Bill's commitment to public service is absolutely undeniable. He has cultivated, supported, and fundraised for innovative programs that not only serve the public interest directly, but that have also helped students prepare for meaningful and satisfying careers in the public service. Bill has used his power, his influence, and his position to secure funding for programs like the Bloom Public Interest Leaders Program, providing full tuition for 8 students a year and almost tripling the level of support for our long-standing PILS program. Bill has allocated resources to establish a series of private-public partnerships for postgraduate fellowships that have benefited more than 200 graduates who have been able to secure jobs in the public interest, and by splitting the fellowship salary with the public sector employer. Bill has used his influence to help launch the DC Affordable Law Firm, partnering with Errant Fox and DLA Piper to hire recent graduates to provide low bono representation to those in DC who make too much to qualify for free legal aid, but yet don't make enough to qualify or to pay for the high cost of legal services. Consistent, absolutely consistent with Georgetown's mission of service to others, Bill lives and truly lives by our law school's motto, which is law is but the means and justice is the end. Under Bill's leadership, we have more than tripled the number of experiential learning opportunities as indicated in the program. We offer more clinics, externships, and practica than ever before. Our students serve in field work and project-based practicums like innovative policing from theory to practice, advanced environmental law with a focus on climate change, international economic law, and sexual orientation, gender identity, and international human rights. Our students also form lasting and meaningful relationships with potential employers through externship placements in nonprofit organizations, legal service providers, and government offices, such as the Senate Judiciary Committee, the House Committee on Homeland Security. And of course, Bill has continued to build upon Georgetown's reputation as having the #1 clinical program in the country. He has hired 6 new clinical faculty in his term, and he has created several new clinics, including the Civil Rights Clinic, the Medical Legal Partnership, bridging the work of the law school and the medical school, and most recently, our Intellectual Property and Information Policy Clinic. So Bill has also, though, used his position and his influence to create and enhance our existing centers and institutes, allowing us to weigh in and offer innovative, cutting-edge strategies to pressing contemporary legal problems, and also allowing us to be a leading voice in national and international reform. Just a couple of our innovative centers and institutes include the Center for the Constitution, the Center for Constitutional Advocacy and Protection, and pilot projects in workers' rights and state and local governments. Bill has also demonstrated an absolute commitment to making Georgetown Law a leading and preeminent school in law and technology, creating, among many initiatives, the Center for Privacy and Technology and the Institute for Technology, Law, and Policy. But most important, Bill has insisted that our centers and institutes not only serve the community, but that they also serve our students by creating opportunities for our students to work as research assistants, allowing them to take classes run and led by the centers and institutes, allowing them to observe Supreme Court moots, and allowing them to engage and observe policymakers and policy analysts. And we know all of this requires funding. As has already been said, at a time when law schools were running a deficit, Bill has managed to find new resources, new sources of revenue, and cultivate donors and increase funding, securing, as was already indicated, over $40 million for these initiatives. And let me be clear, donors like the Ginsburgs, the Blooms, the Delaney's, Agnes N. Williams, the O'Neills, and Sarah Stars would not give unless they trusted that Bill would be a good steward of their resources. They would not give unless they were certain and convinced that Bill shared their vision of justice and service, and they would not give unless they were confident that Bill would spend wisely and equitably across gender, race, and for the benefit of historically underrepresented groups. So not only is Bill a good steward, but he is also a good neighbor. I am proud to serve at a law school that understands what it means to be a leading academic institution in the nation's capital, but also that understands what it means to be a responsible and valuable member of the local DC community. A law school where we care about DC statehood, a law school where our dean can engage directly with the mayor about pressing issues that are important to our city. And what other law school has an Eleanor Holmes Norton Green? Even at Yale, where she attended as a law student, there's only a portrait on the wall. But here at Georgetown, she has an entire courtyard, and that is due to Bill. And I must say, on a personal note, I have been really impressed talking to Bill about the ways in which he is thoughtful and intentional about supporting and partnering with our neighboring law school at UDC, acting not from a place of competition, but really honoring our shared commitment to access to justice and access to the legal profession. So in an era in which the average tenure of a law school dean is only 3.5 years, we are really privileged to have Bill back with us in our 10th year. And as you know, Bill came to Georgetown at one of the most challenging times in the history of American legal education. But when other schools were downsizing their faculty and reducing their class size, Bill did adapt. But he did so by seizing the opportunity to grow in size and to grow in stature and to think about the future of the legal profession and legal education. He expanded our global focus, he launched our business law scholars program, and he deepened our commitment to interdisciplinary scholarship and teaching by conceiving the downtown campus and hiring faculty with dual degrees and cross-campus appointments. In 9 years, has already been indicated, in 9 years, Dean Traynor has hired 60 full-time faculty, 39 of whom were tenured and tenure track, more than the full size of the faculty at most other law schools. But here's what's important. As dean, Bill has never been satisfied to merely replicate what we already have. Of the 39 tenured and tenure track faculty he has hired, 22 are women and 15 are persons of color. Among the students, the most recent entering class included 59% women, 27% people of color, and 11% first-generation college students. Significantly, we have seen an almost 90% increase of African American students in the entering class since 2013. And Bill's success in increasing diversity and inclusion is deeply intertwined with his commitment to making law school accessible and affordable to those who might not otherwise attend. Under Bill's leadership, we have more than doubled financial aid, and we have raised $17 million for our Opportunity Scholarship Program, making it possible to almost double the number of high-merit, high-need students at the law school. We are also one of the first law schools in the country to adopt and accept the GRE score as an alternative to the LSAT, recognizing that the GRE is perceived by many to be more accessible in administration and costs. But Bill understands that we cannot just grow our numbers without also providing all of our students the tools and the resources they need to excel in law school and beyond. Bill has used his power and his position to support the creation of the Office of Inclusion and Diversity. He has allocated resources to establish the RISE program to help students from historically underrepresented groups flourish at the law school, and he has empowered everyone from the Dean of Students to campus ministry to career services, academic advising, and our counseling teams to do everything they can to make sure that we enhance and support the mental health and the well-being of our students. Bill's commitment to diversity, inclusion, access, and opportunity is more than just statistics and numbers. It is personal. It's an impersonal investment for him. And what Bill may not remember is that he and I actually met many years ago back at Fordham, at the time when he was still the dean at Fordham Law School, and I was a pre-tenured faculty member here at Georgetown. And I was at Fordham for a very small workshop for African-American faculty in criminal law. There were just 6 or 7 of us in the room, and the workshop was being hosted by one of Bill's visiting colleagues at Fordham at the time. And while we're listening to one of the papers, Bill walks in and he sits down. And I remember thinking to myself, well, he's not African American. I wasn't too sure he was pre-tenured. And I remember thinking, so who is this? And at a point, there was a break, and he introduced himself as Dean of Fordham Law School. And I was immediately impressed by his sincerity of taking the time, stopping by to say thank you, and to offer all of us words of encouragement. And that is very much who Bill Traynor has been since I have been here. Bill truly understands that leadership is not about hoarding power and exalting himself, but it's about lifting others up and inviting others to join. So let me end by saying that, of course, none of the initiatives, none of the growth, none of the fundraising that I have talked about would have been possible without all of you in the room. But like any good leader, Bill continually lights the way by clearly articulating and modeling the values of the law school. So let me speak for myself when I say thank you, Bill. Thank you for your selfless service. Thank you for your service with humility and compassion. Thank you for your decision-making that is fair and equitable. Thank you for your commitment to making this law school look just a little bit more like the nation and the world in which we live. Thank you for sharing power, insisting upon inclusion, and creating opportunities for the rest of us to lead and to be heard. Most important, I really want to say thank you for showing us that good leaders must be servants first. Thank you, Bill. And I want to call out my colleague, John Mikhail, Associate Dean of Research and Academic Programs. And John will talk about Bill's wonderful scholarship. Thank you.
Thank you, Chris. It's a privilege to be able to participate in today's celebration of Bill. In fact, I feel so honored that I can't help but be reminded of a joke I once heard at a law school event years ago. One of our adjunct professors was receiving a teaching award, and he began his remarks by describing the conversation he had with his wife the night before. He said to her, "Sarah, in your wildest dreams, did you ever think I'd be receiving an award from Georgetown?" She sighed and replied, "John, dear, you're not in my wildest dreams." In case you're wondering, my wife's name is Sarah, and I'll leave it to your imagination whether we have conversations like this. In all seriousness, it is a genuine honor to be asked to discuss Bill's scholarship. It's a tall order because Bill is an extraordinary scholar who has made seminal contributions to a dizzying number and variety of topics. A very partial list would include takings, judicial review, war powers, copyright, privacy, textualism, the Federalist Papers, and most recently, the drafting of the Constitution by the Committee of Style. Bill is one of the nation's most respected and most cited legal historians. His scholarship has been relied upon by the Supreme Court and other federal courts, and he has successfully locked horns with some of the biggest names in the legal academy, such as Akhil Amar, Richard Epstein, and Larry Kramer. So, as you can see, I have a bit of a problem here. How does one even begin to summarize a scholarly career so productive, influential, and wide-ranging? And for the man who decides upon your salary, no less. Faced with this predicament, I'll confess that I briefly considered scrapping the idea of a conventional introduction and just giving Bill an old-fashioned roast. Two factors, however, held me back. First, I'm not that funny. And second, I'm not that foolish. So instead, I'll focus my remarks on just two of the areas in which Bill's scholarship has made an indelible mark: takings and judicial review. I'll say a brief word about each of them and then sit down so you can finally hear from the man of the hour himself. So first, takings. The Fifth Amendment declares that private property shall not be taken for public use without just compensation. In a series of articles that began with his student note in the Yale Law Journal, Bill has defended a strikingly original account of this clause, which challenges the familiar Lockean picture of the founder's devotion to property rights. Bill's starting point is the observation that originally there was no rule requiring compensation when the government took or regulated property. Colonial legislatures regularly took private property without compensating the owner, and none of the first state constitutions had a just compensation requirement. Instead, the decision to compensate was left entirely to the political process. The Takings Clause represented a break with that tradition, but only a modest one, because the compensation principle applied only to direct seizures of land and chattels, not regulations that affected their value. The lesson Bill drew from this history is that our entire regulatory takings doctrine rests on a historical mistake. His note laid the groundwork for this bold thesis and generated a lot of attention. In his dissent in Lucas versus South Carolina Coastal Council, for example, Justice Blackmun cited Bill's note 4 times, a remarkable recognition for such a young scholar. Bill followed this early effort with a dazzling article in the Columbia Law Review, in which he elaborated upon the ideological origins and modest reach of the just compensation principle. Tracing its evolution through Justice Holmes's opinion in Pennsylvania Cole versus Mahan and later cases, Bill concluded that the modern regulatory takings regime initiated by Holmes was both historically inaccurate and conceptually incoherent. He also argued that scholars had not seriously considered the possibility that the original takings clause rests on a principle relevant to modern law, namely the principle that balancing social needs and property rights should largely be left to the political process. In defending a modern process-based theory of takings, Bill did something else deeply admirable. He established and forthrightly acknowledged that the takings clause was likely added to the Constitution to protect slaveholders against uncompensated emancipation. Bill argued, however, that constitutional fidelity requires interpreting the Constitution and the founders' basic philosophical commitments in a way that is sensitive to changed circumstances. Thus, while slaveholders may have been James Madison's own paradigm of a vulnerable interest group needing protection from democracy, Bill maintained that modern courts should require compensation only where a process failure is likely to occur today, in environmental racism cases, for example, or other forms of discrimination against discrete and insular minorities. The depth, creativity, and sophistication with which Bill makes this argument is frankly breathtaking. As Forrest McDonald once said about another scholar, the quantity of his research is massive, but it's combined with pinpoint accuracy in dealing with details. That's Bill's scholarship in a nutshell. But Bill's normative theory of the Takings Clause also displays his philosophical and moral vision, a commitment to the common good and a preferential option, if you will, for the most vulnerable. Well, I could say much more about Bill's takings scholarship, but in the interest of time, let me turn to his work on judicial review. Bill's first article on this topic once again did something entirely new. Writing in the University of Pennsylvania Law Review, Bill produced a detailed study of 2 attorneys' notes from an early case of judicial review, which had never been published or analyzed. Known at the time as the case of the prisoners, the case involved 3 men sentenced to death for treason in Virginia in 1782. The notes Bill located and analyzed were written by Edmund Randolph and St. George Tucker, 2 of the era's most important lawyers. Among other things, Randolph was critical to the adoption of the Constitution in Virginia and served as our first Attorney General and second Secretary of State. For his part, Tucker sat on Virginia's Supreme Court for 7 years before serving as a federal judge for another 12 years. He also edited the definitive edition of the definitive American edition of Blackstone's commentaries. Given how much ink has been spilled on the origins of judicial review, it's shocking to think that 2 men of their stature wrote extensive notes about judicial review, and no one before Bill bothered to track them down and examine them. But that's what happened, and Bill's efforts paid ample dividends. By studying these and other archival records, Bill found that Virginia lawyers and judges not only embraced judicial review, but also appealed to the original intent of the framers of the Virginia Constitution to determine its proper meaning. The latter finding undercut the claim made by Jefferson Powell in an influential Harvard Law Review article that the founding generation thought original intent was irrelevant to constitutional interpretation. Bill also discovered that far from being narrow textualists, the founders were what he called anti-literalists, who believed Constitution should be construed in light of their spirit. Finally, Bill demonstrated that already by 1782, judicial review had won broad support in Virginia, John Marshall's home state. Indeed, Bill suggested that Marshall may have been prepared to defend judicial review in Marbury versus Madison for just this reason. The case of the prisoners was just the first of many times Bill has guided the legal profession toward a more sensitive and informed understanding of judicial review. His deep expertise in this topic grows out of his Harvard doctoral dissertation, written under the direction of Morty Horowitz. Drawing on this background, Bill published a path-breaking article in the 2005 Stanford Law Review entitled Judicial Review Before Marbury, and it supplied the definitive account of this topic and established two key points. First, while previous scholars had identified only a handful of early judicial review cases, Bill found 31 such cases, clearly demonstrating that judicial review was well established before Marbury. In addition, he discovered that all of these cases fell into just three categories, involving statutes affecting the role of judges or juries, state laws implicating national power, or state laws violating the Federal Contracts Clause. The lesson Bill drew from these findings was that the pre-Marbury case law reflected a structural approach to judicial review in which judicial scrutiny was closely linked to the type of statute being challenged. Judicial review before Marbury is a masterpiece, which puts to rest a question that had been debated for over a century. But for Bill, it's really just par for the course. Each of his major articles is a gem and exhibits the same lucid prose, close reasoning, copious research, and measured judgments. They also reflect Bill's patience and high standards. In an essay on Bill, written for our Community Scholars magazine, our former colleague Vicki Jackson drew attention to these qualities of his, noting that when she first met Bill at OLC, she read a brilliant draft paper by him that he did not publish until 2007, even though she thought it was in terrific shape back in 2000. When I read Vicki's remark in preparation for these remarks, I couldn't help but smile because I've had the same experience. The talk Bill will give today is based on a paper he has been writing for many years. My reaction to the first draft I saw was like Vicki's. I thought it was great, and he should go ahead and publish it. But Bill was not satisfied. He wanted to push deeper. And he was right, because the paper has gotten even better over time as he has continued to work on it. When it is published, I have no doubt that it will be another landmark which changes how lawyers and judges think about the Constitution. For any ordinary scholar, that would be a remarkable achievement. For someone who does it while running one of the nation's best law schools, the achievement is really quite extraordinary. But all this just reflects who Bill is. Because you see, in addition to being a lawyer's lawyer and a dean's dean, Bill is and always will be a scholar's scholar. I may be partial, but to my mind, that's the most impressive thing of all. Congratulations, Bill, and thank you for everything you've done for Georgetown.
Thank you very much, John, and also for the remarks that we've been able to enjoy this afternoon from my colleagues. It's, I think, a pleasure to be able to recount everything that Bill has been able to do both, as we know, as a scholar and as an administrator of the law school. And I'm glad that Chris and John were here to give you a brief account of all the things that he's done over the past decade as Dean of Georgetown Law. Now, Bill, the moment has come when I would ask you to come forward for the conferring of the Paul Regis Dean Leadership Professorship. And I will place this rather weighty medal around your neck. And I hope everyone will now join me in congratulating Dean William M. Traynor as the new Paul Regis Dean Leadership Professor of Law. And at this time, I will step aside and turn the stage over to Dean Traynor for his lecture that's entitled The Case of the Dishonest Scrivener, Gouverneur Morris, the Creation of the Federalist Constitution, and Its Laws.
Thank you. Well, I have to say, I'm overwhelmed. I mean, those were really, Bob and Chris and John, those were really such lovely comments. And Jim, you really have been such a hero to the law school. To have you confer the medal on me just means so much. This is, for all of us, first of all, Paul Dean was the giant in the history of the law school. And to be able to have the chair in his honor and to have his family here, means an extraordinary amount to me. And Judy Areen, when she stepped down after her historic deanship, became the Paul Dean Professor. And so it's doubly an honor to be able to take her place as the Paul Dean Professor. So actually a round of applause for Paul Dean. And I'm also touched, that so many leaders of the university are here today. President DeGioia, thank you so much. You've been such a great president, and it means an enormous amount that you're here today. I know you're really interested in Governor Morris, so that's the real reason you're here. And then to be joined by Tyree Jones, who's the chair of the Law Affairs Committee, and our great general counsel, Lisa Brown. Rosemary Kilkenny, who's just our fabulous Vice President for Diversity and Inclusion, Ed Hilton, Executive Vice President for the medical school. It means so much to me. And to have friends and family who've traveled, from all across the country to be here. I'm really honored. Agnes Williams, your commitment to the law school embodies what we're all about. And above all, my children, Liam and Catherine, came back from New York and from Providence to be here. And it wouldn't be a celebration for me if you were not part of this. And above all, the love of my life, Allison Traynor. So yesterday was our 25th wedding anniversary. And it was incredible to be able to reflect on our life together. And as we start our next 25 years, for you to be here for this celebration means more than I can say. So thank you to my family, to my friends, to everyone here, and to the Georgetown law community. Our commitment, as Chris said, law is but the means, justice is the end. This is a law school that really is committed to making the world a better place and to promoting justice. So every day, I'm so thankful to be here. So thank you. So, let me just go back. So the title is actually different from the one that's in your program. The Case of the Dishonest Scrivener, Gouverneur Morris, the Creation of the Federalist Constitution, and Its Laws. So, first of all, that's the dishonest scrivener. Gouverneur Morris, he's seated on the left on this page. So what this is about is, at the very end of the Constitutional Convention, very end, they don't have a constitution. They've been debating for 4 months. They have a draft that is 5 weeks old. They have been arguing about it, voting things up, voting things down. 5 committees. They don't have a constitution. And so they create a committee of style to bring it all together. And style and arrangement, supposed to be style and arrangement. They work over 3 days, and they produce what's our Constitution. Everybody's exhausted, and they just want to get home. So when they get the committee report, in 3 days, they very quickly review the Constitution. They finalize it, and it's our Constitution. Governor Morris, who's the key player on the committee of style, the drafter of the Constitution is, I'm going to be talking to you, he's a dishonest scrivener. So he's supposed to be just codifying and putting the polish on the Constitution. Instead, and the article is online, I'm going to give a overview of it. He makes 15 significant changes in the Constitution. It's 15 substantive changes that reflect what he's fought for and lost on the constitutional floor. It's extraordinary. He's a big nationalist. He's a champion of the executive. He's a champion of the federal judiciary. He fights for private property. He's the only one of all of the delegates who attacks slavery as unjust. And on each of those, he makes changes to the Constitution that are subtle and that people don't pick up on and that become our constitutional text. That's the first part. And then the second part is what happens. And I'm going to talk about how he, on behalf of the Federalists, wins the text, and then how he, really because of his post-convention career and his lack of concern with his place in history, loses the battle for constitutional meaning. So Federalists win the text, but then Republicans win the battle for original understanding. So that's the talk. And again, that's Governor Morris on the left. Okay, how does he do it? Okay, so what the key document is what's called the report of the Committee of Style and Arrangement. So, a couple of things. So when you think back about the constitutional history that you have, when starting when you're in grammar school and that you have in college and law school, it's got a couple of basic themes. The first theme is it's about the Virginians. Okay? And that's because Madison's taking the notes, right? And it's his story, and then he lives the longest, and then his notes are published. So it's all about the Virginians. If the Virginians get together before the convention starts, that the convention begins with the Virginia plan being presented by John Randolph, who we heard about before, Edmund Randolph, rather. And then 2 big floor debates. One debate is over, is representation by the number of people, or is it by the states? And there's the compromise, big states, small states, Senate and House, right? And then there's the big fight over slavery. Is there going to be representation just by free inhabitants, or is it going to be slave people and free inhabitants? And there's a compromise, the 3/5 clause. That's a standard account. And there are 2 ways in which it's wrong. One is, it's not just the Virginians. So if you actually go and you look who's in the room when they're planning what becomes the Virginia plan, it's the Virginians, but it's also 2 delegates from Pennsylvania, James Wilson and Governor Morris. And when the Virginia plan is presented to the Constitution, the first person who gets up and says, "This is fabulous," is Governor Morris. It's clearly a choreographed team effort, right? And then who speaks the most? Is it James Madison, the founder of the Constitution, the father of the Constitution? No. He's third. Number 2, James Wilson. Who speaks the most? Governor Morris, right? Which is a real tribute to Governor Morris because, among other things, he's somebody who, everybody else is concerned with their place in history. He's concerned, he wants a good constitution, but he's a man of business. He takes 2 weeks off in the middle to kind of deal with his business affairs. So whenever he's there, he's talking. right? So he's the one who talks more than anybody else. That's the first thing. Then the second thing is, it's not about the floor debates. It's about the committees, right? Anybody who knows Congress knows how important the committees is. There are 12 committees, and the text that we as lawyers construe is almost all drafted in the committees. And the most important committee, I think, is the Committee of Style. Very end of the Constitution. Again, supposed to be style and arrangement. They write the Constitution in 3 days. And that becomes our final Constitution. It's about the committees, and the most important committee is the Committee of Style and Arrangement. Now, unlike other committees, we do not have contemporary diaries. We don't have drafts of the Constitution as they're writing it. But we do know that there are 5 members: Rufus King of Massachusetts, Alexander Hamilton of New York, James Wilson of Pennsylvania, William Johnson of Connecticut, and Governor Morris of Pennsylvania. James Wilson is there along the side. He's not actually on the committee, but he's part of the negotiation. And of this group, we know that Morris is actually the drafter. And we know that because he writes letter afterwards. That document, the Constitution, was written by the fingers which write this letter. And James Madison, and I have to say, there's incredible tension over time between Madison and Morris. They come to hate each other. But Madison acknowledges that Morris was the drafter. The finish, and he underscores finish, given to style and arrangement of the Constitution, fairly belongs to the pen of Mr. Morris, right? So he's the drafter. Morris is the drafter. Over the 3 days, he's the drafter of the Constitution. Now, as I said, when they come with the draft of the Constitution, over 3 days they review it. Nobody, if you read Madison's notes, nobody says, hey, wait a minute. Some of the substance has changed. Nobody says that. But there's some evidence that there is focus on one particular clause. Okay, this is the General Welfare Clause. So what I've done is I've taken the broadside of the committee's report, and I've blown up the clause about the general welfare. And what I want to do is, and again, read my article. It's on SSRN. Fabulous. So I'm not going to be able to kind of parse all the text. I just want to give the broad ideas. So what goes in on the general welfare clause to the committee? So again, they're supposed to be just taking what they've got and polishing it. Okay? And it's the legislature shall have power to lay and collect debts, duties, imposts, and excises, comma, to pay the debts and provide for the common defense and general welfare of the United States. So what's this? This is about the taxing authority. What is the taxing authority for? They tax for the general welfare and common defense, right? But what comes out of the committee is style. This is why all your blue booking was so invaluable. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, semicolon, to pay the debts and provide for the common defense and general welfare of the United States. What had been a clause about the taxing power becomes a clause about 2 things: about the taxing power, and it's essentially a plenary grant of power, right? The Congress now can pay the debts and provide for the common defense and general welfare of the United States. So, I mean, what Morris is the big nationalist at the convention, and he's lost. And now at the last minute, punctuation. But he doesn't get away with it. Roger Sherman. Okay, now I just want to call attention to the pictures. Governor Morris, remember, smiling, happy guy. Roger Sherman, he's angry. He's caught a typo. So we don't know this from the convention notes, but 10 years after, in 1798, there's a debate in Congress about the General Welfare Clause. And Albert Gallatin, congressman from Pennsylvania, who with Madison is really the brains of the Republicans, he says, during the Constitutional Convention, Governor Morris changed the comma in the General Welfare Clause to a semicolon. But Roger Sherman spotted the trick. That's the word, spotted the trick, and got the language and punctuation changed back. So, we actually don't have, if you read Madison's notes, there's nothing about Sherman calling attention to this. But if you look at
What goes into the Committee of Style is a comma. Its report is a semicolon. And if you look at the Constitution, it's a comma. So that raises the question, what's going on? Is this isolated? Did Morris, in fact, change his clause, or was it just a typo? And then was it part of a larger scheme? And we don't have any response at the time because Sherman is dead and Morris is in Europe. So he never comments on it. He's in Europe a lot. So, now, nobody before me, and I find this amazing, but that's maybe because I'm obsessed by this. Nobody has ever gone through and looked at what goes into the committee and what comes out and written an article or a book that compares the two. Okay, the one person who talks about it is Clinton Rossiter. This is one of the great constitutional history, 1787. It's what I read in high school. And he doesn't kind of detail it, but he says in his book, 1787, hey, I looked at this, I compared it, Morris was fine. Morris was a faithful servant of the committee and the committee of the convention. So nobody has ever before argued that Morris shown that Morris systematically changed the text to win where he'd lost on all the issues that were big to him. Now, there are 4 cases that the Supreme Court has had in the last 50 years in which one of the parties has said, hey, the Committee of Style changed the text. And that where the court has had to choose between the language that went into the committee and the language that came out of the committee. What it's found each time is we're going to go with the language that went into the committee, not the Constitution that was ratified, but the language that went into the committee, the rough draft that nobody ever saw, right? So this is Powell, not obscure cases, Powell versus McCormick, okay, Warren for the court. We're looking at the rough draft, Committee of Style and Arrangement. It's just supposed to be about style and arrangement. If they did anything more, it's ultra vires. So the rough draft is the trump. Now, in some ways, that's not surprising. This is really kind of at the origins of originalism. Now we look at text, not drafter's intent. Jefferson Powell convinced us it wasn't drafter's intent. But the Supreme Court still takes this approach. So this is the most recent one, Utah versus Evans, which is a census case, which is about actual enumeration, which is language that the committee added. And writing for the court, Breyer says, forget actual enumeration, Committee of Style and Arrangement, style and arrangement. We're going to just reject what they added because they were just supposed to be about style and arrangement, right? So the court in the most recent decision is going back to the rough draft. Only one justice has disagreed, and that's Justice Thomas, who says in dissent, I focus on the words of the adopted Constitution. Okay? But he's alone. Justice Scalia has never said that. The only person who's ever taken that position is Justice Thomas. And these are the modern histories. There are 3 really excellent constitutional histories of the past 15 years. Michael Klarman of Harvard, Richard Beeman of Penn, David Stewart, an extraordinary independent scholar. They all say they don't even recognize that this is an issue. They don't recognize that anybody's called into question Morris's integrity. And so David Stewart, again, this is a great book, but he says, this draft, the Committees of Style draft, had to be faithful to the Convention's actions. Morris could be trusted to do that. Well, he couldn't. Okay, now, a little bit of my biography. Why am I obsessed by Gouverneur Morris? First of all, I'm from Morristown, New Jersey. As I'm sure you know, it's a military capital of the American Revolution. This is actually kind of relatively humble. Normally, we Morristonians say the military capital of the Revolution. And when I was a boy, the Gouverneur Morris Inn opened up. Okay? This was a big deal. It was the first hotel in Morristown. This is the local newspaper. New Jersey's first all new hotel in a quarter of a century. Big deal. So we're all Gouverneur Morris. Now, those of you who are Roger Sherman-like proofreaders would say, hey, wait a minute. Gouverneur Morris, that's not the way he spells his name. Well, they actually meant to name it after our Gouverneur Morris. They just misspelled his name. Now, I just want to say that's actually part of kind of the Morristown brand. If you go to if you go to the Governor Morris Inn, which is still open, and you go to the restaurant, Copland's, it's named after Aaron Copland. They misspelled his name too. Okay, now, who was Morris? Now, Morris is really, at this point, he's one of kind of the third level founders. He's not like a Hamilton or a Madison or a Washington. He's not even like, a Mason or a Randolph. He's like a third level founder. There are two things that people remember about Morris, right? Two things. One is I talked about Richard Beeman, one of the classic constitutional histories. In that constitutional history, he refers to Governor Morris as, quote, a serial philanderer. So that's actually a large part of what the histories focus on. If you look at William Howard Adams's biography, which is the standard biography, academic biography, if you go to the index, under romances, under Morris, he's got 37 pages. Under committee of style, nothing. Okay, so serial philanderer. And then the other thing that he's famous for is he's got a peg leg. And, there's a debate among historians about how he gets the peg leg. But one of the stories, which is the one he encourages, is that it's linked to his being a serial philanderer and that he shattered his leg jumping out of a window to avoid a husband. So that's what people know about Governor Morris. But what should you know? First of all, he's physically dominant, right? If you think about the Federal Constitutional Convention, if you go to Philadelphia, it's a small room. And most of them were actually not huge. So James Madison was 5'4" and under 100 pounds. Alexander Hamilton, 5'7", very slight. Commanding is George Washington. This is the classic statue of George Washington. It's in the Virginia state capitol, but it's the one that's copied everywhere. So if you go to the nation's capital, if you go to Independence Hall, if you go to parks across the country, they're all copies of this statue. Now, the face is Washington. So Jean Houdin, the great French sculptor, goes to Mount Vernon, makes a life mask of Washington. That's Washington's head. And Marshall, everybody says, this is Washington. It's in fact, the head is Washington, the body is Governor Morris. And that's because, first of all, there are two kind of things to highlight about that. First, it's just he's the ambassador to France when Houdin is doing the sculpture. They're the same size. Morris and Washington are both 6'4". Think about how big that is at the time. So he knows that they're the right time. Morris gets a little irritated that he's going to Houdin all the time. He refers in his letters to the fact that he's the mannequin. Now, the other thing, though, is that he frankly has a better body. So Washington is, by all contemporaneous accounts, pear-shaped. Don't mean to speak ill of the dead. But, and that's actually good if you ride a horse, because it... But, if you're looking at, are you heroic, that's Morris, right? And everybody at the time says, he has command, right? So he's big, he's got physical command. He's an aristocrat. So if you know New York City, Morrisania in the Bronx, that's his family's estate. This is the house torn down about 100 years ago. So he's an aristocrat, but he doesn't inherit any money. He's from the second family. His father, first wife, the first family gets all the money. Governor is a child of the second marriage after the first wife dies. He gets nothing. He becomes rich through being a very successful lawyer and then businessman, but no inherited money. Okay, other things. He has a gift for friendship, and his friends love him. So when I went back before, and the first image, Governor Morris and Robert Morris.
So everybody knows, not everybody, but everybody in kind of my line of work, knows that Robert Morris went bankrupt. He was the financier of the revolution. He was the superintendent of finance during the revolution. He goes bankrupt. He goes to debtor's prison. What people generally don't know is Governor Morris, who was assistant superintendent of finance, works with him, and then as a business partner, rescues him. He pays to get him out of debtor's prison, and because he has huge debts, he gets him an annuity that can't be seized and buys a house for Robert Morris to live in. For Washington, he's like a son. Washington and he have a father-son relationship. At the end of the Philadelphia Convention, for example, they leave Philadelphia together, and he's Hamilton's closest friend. When he's shot and dying, he's the one who Liza asks to come to the deathbed. So he's a great friend. He is brilliant, according to everyone. Madison and Hamilton, who agree on nothing, both call him a genius. And he is an extraordinary writer of every kind. So he has experience as a legislative drafter when he's in the New York Provincial Congress, when he's in the Continental Congress, when he's assistant superintendent of finance. He drafts the critical legislation. He's a co-author as a very young man of the New York State Constitution. You know, the report that he writes as assistant superintendent of finance, dry report, it gives us two words that everybody knows. He invents the word cent, and he says we should call the basic monetary unit for the United States government dollar. So he has extraordinary gifts at very technical writing, and he's an enormously skilled rhetorician. So if you read the speeches in Farron's reports of the Constitutional Convention, most of them are really dry. You know, Wilson and Morris, very scholarly. Morris is extraordinary. He's funny, he's angry, he's emotionally powerful in a way that nobody can touch. And as evidence of how rhetorically powerful he is, when Hamilton decides that he's going to write the Federalist Papers, he turns to Governor Morris to be his co-author. So we all think of Madison, Jay, and Hamilton. Madison is the replacement after Morris says no. Maybe the most famous understudy in American history. So he's brilliant. He's a gifted writer. The dark side is that people suspect his integrity for a number of reasons. Part of it is his personal life. Part of it is some people think that as assistant superintendent of finance, he benefited himself financially. Most important, in the 1783, there's what's called the Newburgh Conspiracy, which is a planned mutiny of the officers to demand back pay. And the idea is that they will march on Congress and essentially force Congress out of panic to demand a taxing authority. And all the evidence is, and it's widely known at the time, that Governor Morris is the one behind it. So there's real questions about his integrity. So there he is with Robert. So 3 quick shots. So William Pierce, a Georgia delegate, writes a series of mini biographies about all of the other delegates. This is what he writes about Morris. One of those geniuses, that word again, in whom every species of talents combine to render him conspicuous and flourishing in public debate. He winds through all the mazes of rhetoric and throws around him such a glare that he charms, captivates, and leads away the senses of all who hear him. This is the French embassy also writes mini biographies. This is his. Celebrated lawyer, one of the best heads on the continent, but without morals, and if one believes his enemies, without principles. So basically everybody agrees he's without morals. The division is over the principles matter. All right, so let's quickly go to Max Farrand. So Max Farrand is really probably the best constitutional historian. He's the one, the debates that we read today, he's the one who brings them all together about 100 years ago. He also writes a history of the Constitutional Convention. And this is what he says. Governor Morris was probably the most brilliant member of the convention. I just want to stop for a second not Madison, not Hamilton, not Franklin. The guy who writes what I think is the best constitutional history says Morris is the smartest. And then he adds, sharp-witted, clever, startling in his audacity, and with a wonderful command of language. He was admired more than he was trusted. All right. So, let's look at some of the text. And again, I have 15 examples in the SRN article that you'll all be reading this evening. But let's start with the preamble, okay? What goes into the committee? We, the people of the states of New Hampshire, Massachusetts, Rhode Island, and Providence plantations. And then what's the ending of it? Do ordain and establish the following Constitution. Becomes the most famous part of the Constitution. This is all the committee's held. This is all Morris. We, the people of the United States. It's a national statement. We're not the people of the states. We're the people of the nation. And then, what are the ends? There were no ends before, except to have a constitution. To form a more perfect union, to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty. Okay, he has defined, we are a nation, and this is what we're about. That's all Morris. But we also say, well, it's nice. It's a rhetorical flourish. Nobody really cares. What that misses is that in the early debates about the Constitution, the Federalists went again and again to the preamble, not as a rhetorical flourish, but as a grant of power. So, this is just one example. Congressman Fisher Ames, no relation, who's one of his best friends, argues, why do we have the power to create a bank? The preamble. Chisholm versus Georgia. Why does the United States government have jurisdiction over the state of Georgia? James Wilson, who works for the committee, the preamble. So we have this sense that the preamble is just a hortatory flourish, not for the Federalists at the founding. That's example one. The Contracts Clause. Okay. The Contracts Clause is debated once on the House floor, and it is voted down. It is voted down before the Committee of Style begins its work. Now, Morris actually speaks against it, but I think he votes against it because it's too broad on the statute of limitations. It comes back in the Committee of Style report. It's been voted down. It comes back. And I want to highlight not just that he's brought it back, but one significant change. Okay, what's been proposed is that states can't, this is the top, interfere with or affect private contracts. Private contracts. Now we go to the actual report of the committee, which is our language of the Constitution today. States can't alter or impair the obligation of contracts. The word private contracts has disappeared. And this is consistent with Morris's views elsewhere because he thinks when states grant corporate charters, they're done. They can't revise it. So his dropping of the word private is very intentional because he wants it to reach contracts that the state has with private individuals. And so Fletcher versus Peck, when Marshall reads the Contracts Clause that way, most historians say, oh, he's departing from the original understanding. Because in the ratifying convention, most people say, oh, no, it doesn't reach state contracts with corporations. Marshall is just carrying out Morris's language, totally intentional. Okay, John talked a little bit about my work on judicial review. The standard view two generations ago was Marbury was created out of whole cloth. These are kind of Van Alstyne and Bickel are the two classic statements of that. I've shown that there were about 31 cases before Marbury in which judicial review was exercised. But it's also in the constitutional text. This is Morris's speech on judicial review at the convention. He argues in favor of judicial review. But when they go into the Committee of Style, there's no text about judicial review. But then he makes a change. The clause that goes in is that the Constitution and I've underscored it here, shall be the supreme law of the several states. He changes it and makes it, the Constitution shall be the supreme law of the land. And then that becomes, by Wilson again, the basis of the exercise of judicial review in Hayburn's case. And it's also used in a secondary way by Marshall in Marbury versus Madison. So another change. He's added language to create the basis for judicial review. That's not the common wisdom. The common wisdom, most people think judicial review is created by Marbury. He's added language. Okay, the final example I'm going to give it some detail on is the judicial vesting clause. So the general understanding, the common wisdom is, this is the way it works. Wilson and Madison say, got to have lower federal courts. They lose. The countermeasure is you'll have the state courts will be the lower courts, and then it'll go to the Supreme Court. Then Madison and Wilson come in and offer what's called the Madisonian Compromise, which is Congress can but doesn't have to create lower federal courts. Okay, that's relevant for things like jurisdiction stripping statutes, right? Morris wants lower federal courts, and he changes the language. So he changes it from, in such inferior courts, a shall when necessary from time to time, and they may not be necessary. That's what goes into the committee. He changes it to in such inferior courts as Congress may from time to time ordain and establish. So he changes the language. And then, in the initial debates, again, the Federalists use that language, and they say, the language is clear. You've got to have lower federal courts. It's not discretionary. Madison argues contrary to that. He says, they're a good idea. You don't have to have it. Federalists say, no, you got to have it. That's what the constitutional text is clear. Including Morris in his brief term in the Senate argues that. Okay? So those are Now, the Supreme Court talks about the Madisonian Compromise. These are our two textualists on the court, Scalia and Thomas. They both say, when the argument is raised, oh, no, that argument fails because there's the Madisonian Compromise. They don't realize that Morris didn't follow the Madisonian Compromise. He changed it. So those are my basic examples. The preamble, the contracts clause, the law of the lands clause, the judicial vesting clause. In each case, he's changed it to get an end that he wants. And also, Federalists use it to argue for what they want. And the common understanding today, totally against the Federalists. No judicial review, Madisonian Compromise, contracts clause really was just about private contracts. The preamble is hortatory. So he's changed the language. He's given language that the Federalists rely on. And we ignore that today. Just a couple of other examples. The vesting clauses he creates, unitary executive people make a big deal out of the difference between the fact that Article 1 says Congress shall have all legislative powers here and granted. Article 2 says the president shall have all executive powers. That's huge. Myers, it's very important for all the unitary executive theorists when they argue for a broad presidential power. Morris, champion of the broad executive, he puts that difference in. Here and granted, he adds that to the vesting clause in Congress. And then his buddy, Alexander Hamilton, his best friend, relies on that in the first big debate about foreign affairs to say that the president has broad powers. How do we know that, says Hamilton? Because here and granted, Congress just has legislative powers here and granted. The president has all executive powers. So Morris has created legislation that Hamilton is relying on. Too quickly, Morris is a big pro-impeachment guy, thinks it should be broad grounds of impeachment. He then, in the impeachment clause, he changes. What goes in is high crimes and misdemeanors against the United States. He makes high crimes and misdemeanors. He removes against the United States, which is actually very important in, for example, the Clinton, when the question is, President Clinton lied before a grand jury, it's not a crime against the United States. How much effect do we give the omission? Most historians say we'll go back to the prior draft, but that's not what Morris wanted. The other one, which may become a big issue, but nobody's focused on yet. This is the presidential succession clause. What goes in is the legislature may declare by law what officer of the United States shall act as president. So what that means is that that's a term of art. Officer of the United States is members of the executive and judiciary. It's not members of Congress. So he changes that to what officer. He's gotten rid of the United States. So Nancy Pelosi is in the line of succession because of Governor Morris. Final point. He's the only one who speaks against slavery on the convention floor. Domestic slavery was a nefarious institution. It was the curse of heaven on the states where it prevailed. It was a horror. He talks about, this is an extraordinary power, that the admission of slaves into the representation means that the inhabitants of Georgia and South Carolina who goes to the coast of Africa and in defiance of the most sacred laws of humanity tears away his fellow humans, fellow creatures from their dearest connections and damns them to the most cruel bondages. Nobody else speaks against slavery at the convention. And then in the Fugitive Slave Clause, he removes the word justly. So the original, what goes into the committee, talks about the person justly claiming their service or labor. He takes out justly. That's critical. When the abolitionists argue the Constitution recognizes slavery, but it doesn't endorse it, it's because of Governor Morris. So, what happens? Okay, again, what are his goals? Pro-executive, pro-judiciary, strong national government, protection of private property, anti-slavery. He gets language in on all of them. And then the common wisdom today is that's not part of the original understanding. Why? And I think it's because, a number of reasons, but one is because of our worship of people who we consider the great founders, right? And Madison plays it exactly right. He writes the notes and then doctors them to advance his interests. He then has a great career, member of Congress, Secretary of State, President. His notes are then published. He becomes iconic. He becomes the father of the Constitution. So when there are disagreements about what the Constitution means, well, Madison's the father of the Constitution. This is what he says. The preamble is hortatory, right? Madison plays it right. Okay, there are two other founders who could have been the father of the Constitution and who talk more than Madison, Wilson and Morris. Just a few words about Wilson. Wilson explodes. Wilson cares too much for his place in history. So he wants to be the Chief Justice of the Supreme Court. Washington will not, he puts him on the court, but will not make him Chief Justice. I think partly because he's socially awkward. And Wilson is angry. And he wants to be one of the founders. He wants to be one of the premier founders. And if he can't be one of the premier founders, he will be rich. And so he starts to invest. He's on the Supreme Court. He invests in real estate aggressively. And there's a time in which he's one of the 5 richest people in the country. But then the market turns, the panic of 1796, his creditors call in his debts. He has no liquidity. He's sent to a bankruptcy prison. He gets out, but he travels the circuit as a member of the Supreme Court, hiding from his creditors. And he dies over a tavern in ignominy. So nobody says, this is what Wilson thought, because he's become ignominious. Whereas Morris is forgotten. Why? Now, and I just want to say, first of all, he did have a take on this stuff. If he'd endured, this is a letter that he writes. And what he's saying is, when you're interpreting the Constitution, don't look at the drafter's intent or the ratifier's intent. That's confusing. Look at the words. Why does he say that? Because they're his words. Okay, so even though he thinks that, it doesn't become a powerful voice because he disappears from the public after the convention. He's the only one of the major founders who doesn't go back and participate in the state ratifying convention. Hamilton goes to New York. Madison goes to Virginia. Wilson goes to Pennsylvania. he goes back to business. The only record we have of him writing anything down, he goes to Virginia to visit his friend, Thomas Randolph, stays at his house, goes to the Virginia Ratifying Convention, writes poems making fun of the Virginia delegates. Right? That's the only thing that we have from him during the ratifying debates. Then he goes to Europe. He does business he's Washington's representative in England, but he also does business. He becomes ambassador to France during the French Revolution. After he's pushed out by the Jeffersonians, he stays in Europe, making money. Then he comes back. He's briefly in the Senate. And one of the things that tells you a lot about Morris is he's always elected to office because he's so capable, and he's never reelected. So he's very briefly in the Senate, and then when he loses re-election, he returns to private life. He makes some important contributions. Again, if you're in Manhattan, the grid, the avenues and the streets, he's the one who designs that. Erie Canal, he's the major figure in the creation of the Erie Canal. But mostly he's focused on making money. And then, at the age of 57, he gets married. But first, this is Teddy Roosevelt, this is what he says about Morris. And Teddy Roosevelt writes a biography of Morris. And I think of all the biographies, he's the only one who gets Morris. Because he looks around and goes, aristocratic, domineering, smart, trying to get whatever he wants. It's a pretty impressive combination. He sees himself in Morris. So when he writes a biography of Morris, there has never been an American statesman of keener intellect or more brilliant, again that word, genius. Had he possessed but a little more steadiness and self-control, he would have stood among the 2 or 3 very foremost. But he doesn't. He returns to private life. Everybody else is concerned with their legacy. He's concerned with himself. And building a nation is just one chapter of his life. He's got a vision, but it's just one chapter of his life. And then at the age of 57, he marries, this is not a great slide, Nancy Randolph. Okay? Now, whenever I tell this story, people go like, hey, that'd be a great rap opera. Right? I hope so. I hope I get some of the royalties. But if his story is a great rap opera, even more powerful is the story, which is truly operatic, of the woman he marries, Anne Nancy Randolph Morris. So just very briefly. So she's another Randolph. When he's in Virginia staying at Thomas Randolph's house, she's a teenager. Then Randolph's wife dies, he gets remarried, and a second wife, and he pushed the kids out of the house. And they force Nancy and Judith, her sister, into marriages that they don't want with 2 cousins, Richard and Theodoric Randolph. Theodoric, Nancy's fiance, dies. She goes to live with Judith and Richard. She becomes pregnant, probably by him. She either gives birth or has a miscarriage, and he is tried for infanticide. He hires John Marshall and Patrick Henry, and he gets acquitted. So then they all are living together, Judith and Nancy and Richard, in the same house. And then 2 years later, he dies. And some people think it's natural causes. Some people think Judith poisoned him. Some people think Nancy poisoned him. After a couple more years, Judith kicks her sister out of the house. She's an outcast in Virginia society. She makes her way north. We don't know how she survived. And then she meets Gouverneur Morris. And Morris is looking for somebody to run his house. And he says, would you run my house? And she moves in and she runs the house, and they fall in love. And she tells him this story. And he accepts it. He's a little bit worried about the poison. So he writes a letter to John Marshall, the lawyer, and he says, I don't want you to break attorney-client privilege, but you are the attorney, and as a fellow Federalist, I'm thinking of marrying Nancy Randolph. Would that be a mistake? And John Marshall writes back and he says, absolutely, go ahead. And Morris marries Nancy Randolph, and they have a child, Gouverneur Morris I. He dies about 4 years later. If you go to the Bronx, St. Anne's in the Bronx, which is later built by Gouverneur Morris I in honor of his mother, Nancy Ann, is governor's tomb. And the inscription was written by his wife. And, if you read tombs at the time, they're mostly, about horrible things happening. This is unique. It's about love. Conjugal affection consecrates this spot where the best of men was laid. And the last writings that we have of Gouverneur Morris are poems that he wrote about his love for his wife and his child. That's St. Anne's. And this is his philosophy. To try to do good, to avoid evil, a little severity for oneself, a little indulgence for others, this is the means to obtain some good result out of our poor existence. To love one's friends, to be beloved by them, this is the means to brighten it. Now, I don't mean to kind of be too maudlin. He did try to steal the Constitution. But I think you can get a sense of who he was by looking again at kind of the classic portraits of this period. Robert Morris and Gouverneur Morris. James Madison looking off to the right to posterity. Hamilton, same pose. Washington, same pose. Totally different. This is the only major picture of a framer with a friend. And they seem to be enjoying each other's company. So one of the enduring messages of understanding Morris is that while all the other founders cared about their place in posterity, he cared more broadly, in part about the nation, but in part about all the personal things that mattered to him. And so that's really what this talk is about. It's about recovering Morris and seeing him where he's always been present. But we've never known of his influence. Thank you all.
That was just a tour de force. Truly brilliant. Except for the height, the philandering, the deceit, Bill Traynor and Gouverneur Morris have a lot in common. Thank you, Dean Traynor, Dean Feinerman, Dean Henning, Dean Mikhail, and the rest of our guests, President DeGioia, our faculty, staff, and students for attending. I now invite everyone to join for the reception immediately following. It will be held in the Sport and Fitness Center lobby just across the Eleanor Holmes Norton Green. The ceremony is now concluded. Thank you.